If the measure of a society is not how it treats the powerful, but how it treats the powerless, then it's time to get out the measuring stick. Tonight, we check the record of a compelling court case that speaks not only to the fate of one man, but to the integrity of the entire judicial structure in which he found himself ensnared. Christopher Dunn was convicted in 1991 of killing a teenage boy, a court case built entirely on two young eyewitnesses. They later recanted under oath, saying police coerced their statements. There was no murder weapon, no forensic trace, not even a fingerprint. Nothing but a fading and fractured story. In 2020, a Missouri judge reviewed the case and said no reasonable juror presented with today's evidence would convict. At the time, the law only allowed relief for people like that were on death row. Well, that law has since changed. In 2023, under the new statute, the St. Louis Circuit Attorney's Office filed to vacate the conviction. A second judge reviewed that evidence and reached the same conclusion. Christopher Dunn was actually innocent. And yet Missouri's Attorney General Andrew Bailey is appealing. The Supreme Court, in a 4-3 narrow decision, said that appeal can move forward. Mr. Dunn, for now, is free, but not at peace. The Attorney General argues the state and not the local prosecutor holds the finality or final word in these convictions. That allowing prosecutors to correct a wrongful conviction without state interference somehow threatens institutional stability. This is an argument based not on justice, but on jurisdiction. Not on truth, but on turf. The AG says a prosecutor who once convicted someone cannot now advocate for that same person's innocence. But the very law, the Missouri Revised Statute 547.031, was written to allow exactly that. Prosecutors aren't static guardians of past convictions. They're stewards of an active justice. When new facts emerge, seeking to right a wrong isn't betraying their oath, it's their duty to uphold it. Bailey also claims the state is an aggrieved party here. But how is Mr. Dunn's exoneration injuring the state? It's the remedy of an injury, his wrongful imprisonment. To treat justice as something so fragile it can't survive a correction is to value permanence and power over principle. And while the AG warns that exonerations might erode public confidence, what would erode confidence more? Correcting a mistake or fighting to double down and reinstate one, despite two judges now saying the man is innocent? The notion that Mr. Dunn could be sent back to prison after all this isn't law, it's legalism. And legalism without justice becomes mere cruelty and possible control. Besides, who wins here? Not the public, not the victim's family, and certainly not Mr. Dunn, who's already lost 33 years. Let's be clear, this is not about whether the law allows for an appeal. It's about whether the law should ever be wielded in this way at all. The Attorney General does have that discretion, but inherent in discretion is the choice not to use it. In the end, any system which refuses to correct itself cannot command respect. It may command obedience, it may command fear, but never trust. Christopher Dunn's legal fight continues, but the larger trial, the one testing Missouri's moral compass, is already underway, and the jury is we the people.